Now we are excited to welcome Ms. Kobra Moradi, a lawyer in Australia specializing in international law, human rights, and criminal justice. She is currently research fellow at Royal Wellenberg Institute of Human Rights and Humanitarian Law. She will lead our second panel discussion, and we can't wait to hear your insights. Ms. Kobra Moradi, the mic is with you.
Hi, can you hear me now?
Yes, now we can hear you.
Great. My apologies, I had some mic issues. Thank you very much. In this panel, we will be discussing international law, failures and prospects for prevention and protection. Today, we have heard about a litany of deliberate, targeted and widespread attacks against the Hazaras, resulting in displacement, repression and mass killings. And in the words of Dr. Farazu, the genocide continuum or process continues under the Taliban as the situation has worsened, and we are seeing early warning signs of potential genocide, which are evident, including classification, the us versus them narrative, symbolization, discrimination, with the Taliban policies and decrees dividing good Muslims from infidels and bad Muslims. And these are all the different stages of the genocide that we talked about. We are seeing those signs. The Taliban have removed Hazaras from public offices, restricted Shia religious celebrations, and banned Shia Jafari jurisprudence in universities. And armed Taliban forces have evicted Hazaras from their houses and lands, subjecting them to forced displacement across multiple villages and districts in several provinces, including Daikundi, Ghazni, Bamiyan, Maidan Warda, Korzgan, and Ghor. And Hazaras are at continued risk of targeted killings. Just recently, 14 Hazara Shias were killed in Daikundi while returning from pilgrimage. Despite the long history of genocidal acts, ongoing persecution, and early warning signs of an unfolding genocide, there has been no major international reporting, investigation, and accountability. The Hazaras have called on the International Criminal Court to investigate deliberate targeted attacks against them as genocide and crimes against humanity of persecution. Documentation, investigation, and recognition of crimes against the Hazaras based on their identity, both historical and ongoing, are crucial. Without it, denial continues, allowing genocidal acts and the genocide continuum to persist. This panel brings together experts to explore the legal definition of genocide while reflecting on the situation of the Hazaras. It will also examine the role of international law in the prevention and protection of the Hazaras facing genocidal threats. We will begin with Ms. Azadah Mohammad, and Ms. Mohammad is a legal advisor for the Strategic Litigation Project at the Atlantic Council and a PhD candidate at the University of Melbourne. She has worked with Afghanistan's justice institutions, administrative office of the Afghan president, and is an adjunct lecturer of law at the American University of Afghanistan. She's the co-author of a book that was recently published, Handbook on the Universal Jurisdiction, Holding Taliban Accountable for International Crimes. Ms. Mohammad, I have two questions for you. What is the legal definition of genocide, and how does it apply to the situation of Hazaras? And in responding to that question, if you could also reflect on what are the gender dynamics of genocide, and if you could draw on previous cases while also reflecting on the experiences of Hazara women. And the mic goes to you. You have 10 minutes. Thank you.
Thank you very much, Rodan. Can you hear me? All right. Thank you very much. Assalamu alaikum, everyone. Good evening to you all. Good morning and good night to my colleagues in Australia. I'm extremely pleased, and it's such a pleasure to be among you all today. And thank you so much for having me, for inviting me to be here. Thank you so much, Kobra John, for your question, and my response. I will base my responses on the Article 2 of the Genocide Convention, and I will also provide examples of gender aspects of the crime of genocide with the factual situation of what is happening to the women in Afghanistan in the context of the crime of genocide and the definition that we have under the Genocide Convention. In answering your first question, as it was also briefly tackled by the Professor William Milley, the Convention on the Prevention and Punishment of the Crime of Genocide was adopted by the UN in 1948, and it came to force in 1951, and the majority of the states, including Afghanistan, is actually a states party to this convention. The convention also imposes a general duty on states that signatories of the convention to prevent and to punish, which means that the convention provides a positive obligation on the states parties of the convention to intervene in situations of genocide and to punish the committers of the genocide crime. Genocide is also one of the most studied international crime, and like other international crime, we have 4 international crimes. So genocide is actually studied widely by political scientists as well as legal scholars equally. I'm not going to the details of the Article 2 and the definition of the crimes of genocide, which is available in the convention, but to just briefly mention, because I'm answering your question, I just wanted to say that it says the definition of the acts of genocide says that any act that committed with the intent to destroy in whole or in part a nation, ethnic, racial, or religious group. These are the 4 protected groups under the Genocide Convention. Killing members of these groups, causing serious bodily or mental harm to the members of the group, deliberately inflicting the group conditions to life calculated, bring about physical destructions in whole or in part, and imposing measures intended to prevent births within the group, and forcibly transferring children from one group to another. So while unpacking this definition, so this is a definition of genocide under the Genocide Convention, which was adopted more than close to a century now, we can see that there's a lot of criticism to this genocide, this definition of this crime of genocide. For example, first of all, the legal scholars and legal practitioners also maintain that the threshold for the crime of genocide is extremely high. Threshold means that the level, that the seriousness of the crime. That the definition is also very narrow. It doesn't encompass a lot of acts that could be potentially genocidal, but it doesn't cover it. So it means that most of the acts that, or the situation, like the Hazaras potentially, that could qualify as a genocide does not fall under this definition, unfortunately. I'm not saying that the Hazara genocide does not fall, but I'm just giving an example. It is often very difficult, therefore, to apply it in specific cases, in specific situations, and it does not cover a lot of situations as a result of the very narrow definition and also the threshold of the crime being very high. At the same time, the critics also says that to prove an act is genocidal, the intent element and the definition of the crime should be proven beyond a reasonable doubt. Proving beyond a reasonable doubt is a legal terminology, which states that actually an act should be proven beyond any doubt that this act has been actually committed to qualify as a genocide, and that the alleged perpetrators intended to physically destroy a nation or ethnic groups as under the Genocide Convention. At the same time, Article 2 of the definition of the crime of genocide maintains that genocide is a physical destruction in whole or in part. This inclusion in whole or in part terminology within the definition can also be could be potentially very problematic, because the whole, while assessing a particular situation or whether it is genocidal or not, there are no means to defining what does it mean by in whole or in part. In other words, how can we actually measure that, and how many deaths or how many killings can actually qualify as genocide, or what is the how many number of dead people can actually qualify the threshold or meet the threshold of the crime of genocide or qualify as a crime of genocide. But sometimes a lot of scholars and also legal practitioners maintains that genocide is a crime that you don't need killing for the genocide to meet the threshold of the crime of genocide. So without even killing one person, you can prove that the crime is genocidal. So this and whole and part can be very problematic in the definition of the crime of genocide as we have it today. And then also the critics of definition of the crime of the genocide, the definition of genocide also maintains that as a result of this definitional shortcomings, it is often very difficult for the international community to intervene to prevent a particular genocide. For example, the United Nations is repeatedly to date is actually being held responsible, is being blamed for very long hesitation when they had very clear signs of the Rwandan genocide and Bosnian genocide. The UN staff had actually traveled to Rwanda. Rwanda is a country in Africa, for the colleagues who need a little bit context, that one of the genocide happened in 1993. UN member mission was actually there when that happened, and they had actually informed their headquarters, like the same as we have been witnessing in the Taliban-controlled Afghanistan. Even before that, in the past century, that the situation of Hazara is also qualified as genocide, but we have no inaction from the international community. And the UN, so Rwanda experienced the same, and the United Nations and international community did not intervene in the case of Rwanda to stop this, to actually take these early warnings very seriously, and also potentially to stop the genocide that happened. And within just 3 to 2 to 4 months, more than 800,000 people estimatedly from one particular group was killed as a result of that. And the same goes with the Bosnian genocide of 1994. The previous speaker, Dr. I think Regina, if I remember your name correctly, said that there are established early signs of genocide, and it is often overlooked because of the mentioned definitional issues sometimes, and also politics of genocide. Like often the people think that we can call a particular, if we call a particular situation as genocide, we could potentially dilute the meaning of genocide, and any situation can be called genocide. Like most of the international crime, genocide has a very negative connotation to it. I think there was a question from one of the colleagues in the former panel who said that sometimes advocating for Hazara genocide, we lose our friends, we lose our colleagues who are becoming very sensitive about this, that why do we call the situation of Afghanistan as a Hazara genocide? Well, a lot of people are dying and the violence is widespread across the country. It is because of the negative connotation and because of the advocacy that the genocide actually holds with it. And right now we always say that the Taliban is committing war crimes against humanity, not everyone actually paying attention. But the moment we say the Taliban, or the not even Taliban, but the Afghan states before the Taliban have been committed acts of genocidal acts towards Hazaras, suddenly everything becomes very sensitive and everyone becomes really annoyed with that, because genocide generally internationally also has very negative connotation, and that's not unique to the situation in Afghanistan. So to move from the critics of the definition of the genocide, the crime of genocide is called the crime of crimes. It's the most serious crimes and the 4 international crimes under the Rome Statute of the International Criminal Court, and then because it has an intent or mental element to this crime. The definition of crime of genocide consists of 2 particular elements, like the physical elements, actus reus, or the acts that committed. The acts that committed of the genocide could be the killing, extermination of a protected group, and then the mental element or mens rea of the means that to intend to destroy or to kill. The intention element is very unique to the crime of genocide. So the mental element, the special intent, makes the crime of genocide extremely unique. For example, to establish that an act is genocidal, we need to prove that victims are deliberately targeted for their distinct identity, which is protected under the Genocide Convention, rather than randomly being killed. In terms of our situation, or the Hazara situation in Afghanistan, we have many such examples, or the recent incidents that can be argued that they are in fact genocidal. For example, just before the fall of Afghanistan, the Republican government of Afghanistan in 2000, I think it was 2020. Please correct me, colleagues. I don't have a clear recollection, but I think that they're in one of the northern provinces of Afghanistan. I think a member of armed group has actually came into the miners. I think they were from this international organization who were clearing the mines. They actually went to their hostel, and then they asked specifically for the Hazara members of those mission that were actually in that region, and killed them, or some of them was in hiding. And the clear example is also the 14 people who were deliberately killed. And this personal story that we have, all of us have actually lost someone who was deliberately killed because of their Hazara identity. And I have lost 2 teachers in the highways that among all the passengers in the bus, they were actually identified as Hazaras, and they were deliberately taken out of the bus and being killed. As Dr. Farkhonda Akbari also mentioned, the deliberate attacks on schools, hospitals, educational centers also signifies that we are being attacked and targeted based on our specific identities. So just briefly, before I go to your second question, if I have time, the venues for accountability for genocide is the International Court, International Criminal Court, and they for criminal prosecution, and then for violation of the crime of genocide, we have the International Court of Justice, which is also, both of these courts are in The Hague of the Netherlands, and then we also have universal jurisdiction. I recommend that you read the recent book publication that we had on the universal jurisdiction that I have shared with some of the organizers of this conference, which is also for our diaspora group, for us to see how can we actually advocate for that, for in the accountability for international crimes. In terms of your second question, Kobra John, the gender dynamics of genocide, gendered elements of international crimes have historically been very significantly taking a lot of time to be recognized or to be included by the international community, as currently we are advocating for the inclusion of gender apartheid, to the criminalization of gender apartheid under the new Treaty on Crimes Against Humanity, and to recognize Taliban as a gender apartheid or as an apartheid state. We have been receiving a lot of backlashes by the international community, by some scholars, practitioners, saying that while we have gender-based prosecution as a crime under the international treaties, why do we need gender apartheid? So to answer critics, we usually say, which is also very relevant to in terms of the crime of genocide and the gender and genocide, we say that for legal and policy reasons, because whatever is happening in Afghanistan right now is unprecedented violation of international crimes and the crimes that have been happening in Afghanistan. So in terms of legal policy, we want to hold the perpetrators or the Taliban for the committing these crimes for the totality of the crimes, because Afghanistan is the first situation or the country in the world that girls are systematically, institutionally banned from going to school. That's just one element, right? So I usually try not to forget the other elements of Taliban's crimes on ethnicities, on Hazaras, and on vulnerable groups while we talk about gender aspects, but it is important to mention it. And in terms of policy, we don't want any normalization or recognition of the Taliban as a legitimate government of Afghanistan. And then the apartheid states, for example, in South Africa, that the word apartheid comes from in the 1990s, the international community, as soon as they recognize that South Africa is an apartheid state, they intervene to topple that government and then to not normalize their relationship with that government. So that's the other reason. And the same case goes for the crime of genocide. While discussing the crime of genocide in a strict sense of the crime of genocide, we usually comes to mind that the mass killing directed towards a protected group or the intention of killing, of extermination of a protected group can actually constitute genocide, while non-killing act element, as I mentioned, that the intention, right, non-killing elements of the crime of genocide is very much overlooked, which is very much also gender-based and directed towards women and girls in a genocidal acts, and took very long to be identified as a genocide. As I previously mentioned, the elements of crime of genocide, and we had no mention of gender. So gender aspects of the crime of genocide for the first time was discussed after the 2 events in the 1990s, the genocide in Rwanda and genocide in former Yugoslavia or Bosnia. With massive gender-based and sexual perpetrated during these 2 cases, unfortunately. And landmark case in this was called after a Rwandan politician or a mayor. His name was Akayesu. I recommend colleagues to read this case. Who was convicted of multiple crimes, and among them was genocide, and his case for the first time raised the topic of gender in the crime of genocide. So for the first time in a genocide case, the court found that the rape and other acts of sexual violence could be constituted as acts of genocide. So women in general have been suffering from non-killing elements of genocide. So while they were not actively being killed, they had other form of serious violations or serious violence against them, including the slavery, sexual violence, massive rape, and also termination of pregnancy, enforced pregnancy against them. As Dr. Akbari also mentioned in the previous panel, it is important to note that violence directed at women and girls during genocide is actually rooted on the existing misogynistic attitudes in society, and the traumatic impacts are magnified by financial, social, cultural inequalities to which women and girls are actually subjected. The recent internationally recognized genocide of Yazidis in Iraq and Syria, and the horrifying ordeal of Yazidi women is well documented, and where they were actually have been taken as slaves. And the Nobel laureate Nadia Murad's story is very much very sad, but I actually encourage colleagues to read her story. Is a clear indication of the role of gender in genocidal cases, which is also extremely very similar with the experience of Hazara women, that stories that we have been hearing from the past. The same has been applied to the Hazara women. Hazara women have been taken as slaves and sold publicly. If we could actually rely on the narratives or the historical record, we know that I think there's a Puli Dupaisei in Kabul. It's called Dupaisei because based on so many narratives and historical accounts, Hazara women were actually sold there as slaves, and Hazara girls were sold there as slaves. And to date, Hazara women are being regarded differently in the Afghan society, and also mentioned, I think, by Sirat Saib, and also by Alizoda Saib, who said that based on the interviews that I have been also involved in some of these interviews with the Hazara women who were tortured, who were arrested and tortured by the Taliban, they said that their experience was extremely different than the other women from the different ethnicities in the Taliban prisons. So this actually shows that negative and that attitude, the genocidal attitude, the intent of that intent still exists, and then we can prove it by such treatment. We all saw the Taliban mullah. I think he was in Panjshir, I think, but he's a Taliban mullah who said particularly called on Hazara women to be arrested for not following the Taliban's dress code, and Taliban deliberately concentrated their arrests on the women of Hazaras in the most of Dashbarchi area and other areas which is actually predominantly populated by Hazaras and Tajiks as well, but mostly Hazaras. As a final remark, Kobra John, I think I took very long. I just wanted to say that it takes very long for the final act of genocide to take place. The final act of genocide is the actual killing, mass killing of these four particular groups under the definition of the genocide. So before the final act or before the killing takes place, there are clear signs and warnings that of the mental element, the existence of mental element is there. And then those mental elements are marginalization, dehumanization, and then we all have, unfortunately, personal stories of how we have been discriminated against and how we have been treated as Hazaras, as Hazara women, as Hazara man in Afghanistan, and how our fellow Hazara men and Hazara women are being treated right now in Afghanistan for their specific ethnical and religious identity that we hold, right? So Taliban's attitude towards Hazara is not something that new. It's a product of century-old attitude towards Hazaras. It's extremely genocidal, and then Taliban has been committing this, or the Afghan state in general have been committing these acts with complete impunity, and the international community is yet again taking very long to respond to these serious warnings. And I think that it is time for us to take it very seriously and call on the international community to fulfill their obligation under the Human Rights Convention, under the Genocide Convention, as well as the international law and ethics and morals in general. Thank you, Kobra John. I think I'll stop. I'm so sorry for going over time.
Thank you, Azadah John, for setting out the legal definition of genocide and also explaining really well the gender dynamics of genocide and how it applies to the situation of the Hazaras. And now we move towards the focusing more on prevention and protection. Our next speaker is Mr. Musa Mohammadi. Mr. Mohammadi is a research fellow in law at the H.S.A.I Center for International Human Rights at Yale Law School. His research and work focuses on accountability, transitional justice, victims' participation in criminal proceedings, justice reform, and minority rights. He served as the executive director of the Afghanistan Independent Human Rights Commission for 10 years in Afghanistan. Mr. Mohammadi, thank you for joining us. The question for you relates to failures of international law in Afghanistan and the lessons learned. So the question is, what are the key failures of international law in protecting vulnerable communities like the Hazaras in Afghanistan and preventing atrocity crimes against them. What can we learn from these failures going forward? And in the future, what can Afghanistan do better to protect and promote the right and survival of marginalized groups in Afghanistan? Thank you, and over to you.
Um, Good morning again, and thank you, Melissa, and thank you for correcting my last name. It's Mahmodi. The issue in hand was covered by our scholars and leaders in the field of promotion protection of minority groups and Hazaras. I don't have much to say, but in order to specifically answer your question, I should start that today we confront an uncomfortable truth, and that truth is that there is an inadequacy and lack of effective application of our international legal system, and there is a consequences of that world collective inaction, and we see that not in Afghanistan but in many other parts of the world, from Ukraine to Middle East to Syria and to many other places, and in particularly in Afghanistan. The Hazara people of Afghanistan have endured systematic persecution, targeted violence, and genocidal attacks for more than a century. Despite the presence of international conventions and legal frameworks designed to prevent such atrocities, the world has repeatedly failed to safeguard their rights and protect them from harm. Even when 140,000 troops were present in Afghanistan, and they did nothing. When the UN mission in Afghanistan had the strongest and the most resourced, mission established in Afghanistan, unfortunately, they didn't match to protect minority groups and Hazaras. And this failure is not just a gap in a legal mechanism, it is a failure of international community's moral responsibility and also discharging their duties. And it's not only a legal shortcoming, but a profound omission of the very responsibility that the international community claims to uphold. So as Azadah Mohammad mentioned, we have in theory, the tools to prevent genocide and protect vulnerable population. And the 1948 Genocide Convention that Afghanistan became part of in 1956 defined the crime of genocide and obligate the states to prevent and punish genocide. And also we, later on in 2005, the responsibility to protect principle asserts that the international community has a duty to intervene when a state fails to protect its people from mass atrocities. Afghanistan also became a member unsigned ICC, the International Criminal Court Statute, the Rome Statute, and the International Court of Justice have jurisdictions over Afghanistan as a member state, as member of also convention that gave these jurisdictions to the ICG, and they are designed to ensure accountability when national systems fail. Yet these tools are, rendered meaningless, and they have been ineffective when there was the question of their enforcement. And it is generally left at the mercy of political will and states' cooperation, and nothing more than that, because we see that the truth is that these mechanisms are only as effective as when there is a commitment to use them. as Kofi Annan, a former UN Secretary General, once said, quoting him, the failure of the international community to act is not a failure of capacity, but a failure of will, an end of quote. So the Hazaras have been systematically targeted. This is a fact due to their ethnic and religious ethnicity identity. The reply has been met with silence or at best symbolic condemnation. We only see from the international community putting a statement um, uh, condemning attacks against Hazaras in Afghanistan. And most of the time, it's not even Hazaras. It's called civilian, while as it is well established under the Genocide Convention that um, there was an intention to destroy Hazara community as a group, as an ethnic and religious group. Uh, and those elements of crime have been, in cases that was both mentioned in previous discussion points, but also, has been very well documented. It's evident. Um, so there hasn't been any uh, 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 effective action. So when the Hazara lives are at stake, condemnation without action, I think, maybe be only a complicity and nothing more than that, because the international community has not exhausted or used effectively the tools that they have designed to prevent atrocities and genocide. Uh, Again, from Kofi Annan's word, there can be no more important issue and no binding obligation than the prevention of genocide. And uh, uh, and the scholars like Barster, Schiff, and Bear says that it is the international responsibility to preserve international security, to protect human rights, and to end impunity for grave crimes. Genocide is not just a crime; it is the international crime of the crime. So uh, it is the crime of the crime. It is the most egregious crime that ever committed against any population in the world. So we see this uh, elements of crimes, how this happen, especially in the access areas and Syria that Azadah have mentioned. We had incidents like attacking maternity hospital. It was attacked in 2020. Armed attackers stormed the maternity ward at Dashti Barchi hospital, killing 24 people. This attack was against Hazaras and against Hazara mothers, against Hazara babies. It was very well known that this is a Hazara area, and this attack was in line with very much with the intention of the groups that systematically and continuously attacked Hazaras, uh, everywhere they could find them, either in Baghlan in Hello Trust camp or in Jalalabad in a mine, or in Paktika on the road, or in Zabul like Tabassum and the road. So there have been evidence of those crimes being committed both by the Taliban and later, the SKP came in the view, and they claim many of these attacks responsibility. Uh, the Taj Education Center, I think everyone have a fresh memory, unfortunately, tragic incident that suicide bombing targeted Hazara students there. And the recent attack on Hazara people in Daikundi, that 14 of them killed, just being Hazaras. So these were with the intent to destroy Hazara population, and we can, through uh, asking for comprehensive and dedicated international investigation to establish the intent and to the that the crimes of genocide have been committed in Afghanistan and are being committed, and there are clear signs as early warning that Hazaras are not safe in Afghanistan, and they are very much in danger of uh, genocide intent. So we have been, as Afghanistan, as a state, as a country, signed the major 7 international covenants, the International Covenant on Civil and Political Rights, the Convention Against Torture, the Economic, Social, and Cultural Rights. The Afghanistan signed the ICRC, the IRC, the International Covenant on Rights of Children. The C.I.D.A., the Convention on the Elimination of All Kinds of Discrimination Against Women, and Afghanistan also signed into ICC and ratified them. And these conventions became both laws because it was approved by the parliament and published in the Afghanistan Gazette, and also Afghanistan domestic laws were reviewed to comply with the provisions of these international covenants and its protocols. The latest one was the Afghanistan Penal Code that not only complied with the most of the provisions of this important international human rights law, but also directly incorporated the definition of international crimes, the 4 international crimes from the ICC, and adapted that, and it provided an opportunity to litigators and also to prosecutors in Afghanistan and the court that to bring perpetrators of genocide and atrocities to be tried under these provisions now, very well defined by Afghanistan Penal Code. And I always tell this sad story that Islam Faraqi, the leader of SKP, was detained by the Afghanistan government, but we had the law to try him and his followers because of so many atrocities from Mirza Walang to killings and attacks in Kabul to bring him and to try him. And there was institution, there was court, there was law, and unfortunately it was not done, and it was not clear to create a precedent to bringing perpetrators of international crimes or the crimes of genocide, crimes of crime against humanity and war crime to court. So these opportunities are lost, but now it is we cannot expect, or we do not expect anything from the Taliban group that is taking over Afghanistan and ruling by oppressing people, denying their daily human rights, and facilitating the environment, either through allowing the non-state actors to kill Hazara people and inflict harms to the communities that are vulnerable in Afghanistan, or allowing the conducive environment like crazy mullahs in social media spreading hatreds against the Hazaras identity, religious looks, features. I'm sure you have not only heard from mullahs sitting in Kabul and spreading these hatred speeches, but mullahs sitting in Western countries calling Hazaras Bini Puchuk, or the flat nose, what they are wanting, or the same dehumanization and demonization cliches attributed to Hazaras that they would, pee in their foods when it's brought to, their guests from other sects. And this level of hatred speech and demonization is not abundantly available in social media broadcast from Afghanistan, but also, coming from mullahs enjoying the freedoms and rights of to freedom of speech in the Western capitals or cities. So that's a fact, unfortunately, and that not only the international law framework has failed to protect Hazaras in Afghanistan, but also it hasn't been able to monitor effectively to prevent the spread of hatred speech
Mahmodi,
and
my apologies.
perpetuating the situation as it is. Yes, Moradi, you were saying something. Sorry.
My apologies if you could wrap up because of the time limitations.
Okay, sure. Sorry. So what I can see as a lesson learned and what we could do, I think Afghanistan lost an opportunity to bring to justice the perpetrators now, apparently. Now it is all eyes should be focused on ICC because that's the only permanent tribunal that has jurisdiction over Afghanistan. We also should resort to other means available for litigation at the international level, like we recently have heard about this advocacy bringing Afghanistan before the ICJ on SIDA. We also could see a possibility to bring Afghanistan to ICJ because of the Genocide Convention. We also could resort to the universal jurisdiction. I should congratulate Azadah for the excellent work that she put out for guiding, litigators and advocacy groups outside. We also, frequently refer to the international UN treaty bodies. They are also a mechanism that we could use for protection of vulnerable Hazaras in Afghanistan, especially women, because Hazara women are not only persecuted as a woman, but also persecuted and are in danger because of their ethnicity and religion. I will stop here and I will be very happy to answer questions. Thank you.
Thank you very much, Mr. Mahmodi, and thank you also for mentioning, highlighting the fact that Afghanistan had signed on to many international law conventions. So if I would have reframed my questions, it's more of a lack of political will or political failure to make use of the legal instruments, mechanisms, and international law that were available in order to promote and protect the rights of vulnerable groups, and also highlighting the need for action, the state obligation to comply with their international law obligations. And in that regard, we will be moving to our next speaker, Dr. Andrea Gittleman. I hope I have pronounced your last name correctly. Dr. Gittleman is the policy director for the Simon Scott Center for the Prevention of Genocide, where she leads the center's policy outreach and country-specific work, as well as efforts relating to justice and accountability for mass atrocities. Previously, she was interim director of US policy and senior legislative counsel at Physicians for Human Rights. Before that, she served as the Arthur Hilton Global Human Rights Fellow with the Burma Lawyers Council. Thank you for joining us and giving us your time. I have questions for you about the meaning of the obligation to prevent and punish genocide. What does this mean, and what does this require states and the international community to do, and what are some preventative tools that are available internationally to use, and how do these tools apply to the situation of the Hazaras? 10 minutes and over to you. Thank you.
Great, thank you so much. I hope people can hear me. I thank you for that kind introduction, and really thank you to the organizers for organizing this important conversation. It's really an honor for me to be included in this distinguished panel. So I think the panelists and the experts before me have done a remarkable job explaining the law of genocide and how it relates to crimes facing the Hazara and to Afghanistan in general. I'll just speak briefly, as you mentioned, about what it means to prevent and punish genocide, what states can do to hold up this obligation under the law, and then how it applies to Hazara. So what does the obligation to prevent and punish mean? So the Genocide Convention, which was described earlier, it lays out the obligation for states to prevent and punish genocide, but it does not explain at all how states should go about fulfilling this obligation. So jurisprudence shows that states' obligations relate to their capacity to effectively prevent and punish genocide. So there are a lot of questions about what we should make out of this obligation. In the Bosnia v. Serbia ICJ judgment, which is often cited, it mentions that a state has an obligation to prevent and the corresponding duty to act. And that obligation is instant when a state learns of, or should have learned of, the existence of a serious risk of genocide. So what we take from this is that in order to truthfully uphold the obligation to prevent genocide, a state should work to identify and analyze risk factors in order to understand the risk of genocide, because how the obligation is triggered before genocide would be committed in order to effectively prevent, then states then have the obligation, it would seem, to try to understand what those early warning signs could be. So which risk factors have a link to genocide? How should states go about identifying those factors? And then once identified, what should states do to mitigate those risks? So I'll speak briefly about that. So in general, there are risk factors that relate to either widespread and systematic discrimination. We've heard about that from other experts explaining the experience of Hazara for a long time. And other risk factors that relate to life integrity violations, kind of physical violence, crimes against the body, things like that. And our museum, the U.S. Holocaust Memorial Museum, uses an approach which has been used by Professor Scott Strauss, which includes the following structural risk factors. So risk factors that don't change a lot moment to moment, but those risk factors are large-scale instability, armed conflict, transformative or exclusionary ideology, and prior discrimination and violence against a particular group. And so each of these structural risk factors, these things that exist kind of over the long term, these are evident, as those here know, in the case of the Hazara in Afghanistan in recent years. There are additional warning signs that might be more proximate, kind of not as long-term, but more of the sign that mass violence against a particular group might be imminent. And those more proximate risks could include tension and polarization, apocalyptic public rhetoric, labeling civilian groups as the enemy, deploying or using irregular armed forces, stockpiling weapons, emergency or discriminatory legislation, removing moderates from leadership or public service, and impunity for past crimes. Not all of those risk factors will exist in every case, but those are things that generally might give you the sense of a high risk for large-scale mass violence against civilians. And this is drawn from past cases where we've seen these warning signs, and we have seen an eruption of a targeted mass violence against a particular group. And as has been noted and previously in the panel, genocide is a specific crime. It turns on a specific intent to destroy a particular group. So these risk factors may result in mass atrocities against the group. That violence may meet other elements of the crime of genocide. So I wouldn't consider the risk factors to be any sort of checklist to go through, or kind of a list of items where if these things happen, then we will see a particular result, but rather things to look for to kind of gain an awareness early on if there is specific risks facing a particular group. And so the presence of one or more of these risk factors doesn't necessarily mean that a genocide will take place. There's no specific formula to predict, but in terms of the obligation to prevent, the presence of some of those risk factors should warn a state about the existence of a serious risk and that it should take serious and effective efforts to mitigate that risk. And clearly, as has been discussed today, and I think all of us are well aware, states in general are not upholding their obligation to prevent and punish genocide. But it's essential for states really to identify early warning signs just as a first step. The UN has an atrocity crimes framework. The US government, I'm sitting in Washington, DC, has an atrocity risk assessment framework. So there are tools that can help identify and analyze early warning signs. And this should be routine among states, among civil society. They're public. We know from past cases of genocide and mass atrocity that these crimes are not inevitable, that there are warning signs, and my fellow panelists explain this as well. And to have any hope of effectively preventing genocide, states will need to focus on identifying these early warning signs and developing tools for effective response. And then I think the question is what are the potential tools for response? So even if we think about some of these risks, we have a sense that there might be discrimination, persecution, targeted violence against a particular group. What can states do in order to respond? And we often think about the atrocity prevention toolbox. That there are a lot of different options that governments, that states can use in order to mitigate some of those risks that I mentioned. So among them would be to reduce discrimination, to promote ideologies and values of pluralism and tolerance, to enhance legal frameworks for human rights, to end impunity and ensure justice for past victims, reforming security sector, preventing or mitigating conflict, and that can be done in various ways, or using security assistance or trade policies to help induce positive change. Not every tool will be appropriate in every case and at every moment. So I mentioned these just as an example of there's a range of tools that could be available to states. So mentioned risk factors and tools. All of that only makes sense if risks and tools are understood as part of a broader atrocity prevention strategy. A strategy will help determine which of those tools could be used, which makes sense in a particular case, and how best they are to be implemented. So a strategy can be designed to, for example, discourage potential perpetrators from committing mass atrocities, making it costly for them to do so, making them change their own calculus. Or you could have a strategy that focuses on degrading the capability of perpetrators. Maybe perpetrators will not be dissuaded. They will still very much, keep those ideologies or the inclination of violence, but they're less physically able to commit those crimes. Or strategies that focus on protecting vulnerable communities. And so how does this apply to the H.S.A.I population? Because that was one of the questions that you posed. So we might think about the following, and I say this with a good amount of humility because I am not an expert on Afghanistan or H.S.A.I, and I'm surrounded by people who are. So I'm just saying this as there are examples of some options that could be considered, but these are options, and that this isn't a specific menu, or there isn't a specific course of action that if pursued could prevent mass atrocities or redress crimes that have taken place. So in terms of dissuading potential perpetrators, making potential perpetrators less likely to want to commit mass atrocities, there are things that can be done to pursue accountability options, and I think both the previous panelists addressed those, but that could be working with civil society organizations in or from Afghanistan to explore their views on what options for justice and accountability they might support and what they feel is the most important. There can be efforts to coordinate support for accountability initiatives, which again should be informed by the demands and expertise of civil society organizations who have experience here, including from H.S.A.I organizations and experts that can take a holistic understanding to address violations, by all perpetrators and against multiple groups, There was, I think, a really rich discussion earlier about the gendered nature of crimes and the kinds of crimes that might get more focus or more resources dedicated to documentation. And so I think it's important to keep that in mind when we're pursuing support for accountability as an atrocity prevention policy, making sure we're including voices from different communities, from women, from people with disabilities, and people who might have very different experiences in a particular situation. Strengthening the monitoring and documentation of abuses, I think, would be really important. And then focusing intelligence collection. So not just civil society documentation efforts, which is very important and also quite dangerous, but also states with the capability to collect information should be dedicating resources toward that so that they also can do their share in supporting accountability efforts. Another strategy that I mentioned about kind of degrading the capacity. So even if perpetrators cannot be dissuaded, they still, they very much are motivated to commit mass atrocities. There are certain tactics that could restrict their access to weapons, for example, to make them less likely or less lethal. You could develop technological systems to limit the ability for perpetrators to organize and impose greater costs on perpetrators. So this depends on the particular group, but public recognition that could dissuade some, but not all. There's some perpetrators for whom public attention does not deter them, and just kind of creative efforts. H.S.A.I, as was mentioned before, has co-authored this really fantastic handbook on universal jurisdiction efforts, and I think that's something that's worth serious consideration. And then, protecting vulnerable civilians, engaging with affected communities to understand the risks that they face, supporting civilian self-protection efforts. I mean, civilians should not be in a place where they need to protect themselves from mass atrocities, but too often they are, and they deserve the support of the international community. They deserve information and resources to be able to do that effectively. Digital security training in contexts where it could be dangerous for civil society groups to organize online or to do documentation efforts. They should be made as secure as possible for the people taking great risks to do this work. And finally, supporting local education efforts. There are groups, as you well know, who are doing really important locally led efforts to really build new generations of civil society leaders, including among H.S.A.I, and this is really essential in such a difficult time. So I'll just stop there. I mean, these are just examples, but I think the participants here would have many more ideas of things that can be done to kind of further some of these strategies to prevent mass atrocities. Thank you.
Thank you very much, Dr. Gittleman, for explaining the duty to prevent and punish genocide, but also providing such a comprehensive tools and options that are available to at-risk groups, including the Hazaras. Next, we're moving to Dr. Arif Saba, who is an Associate Research Fellow at the Alfred Deakin Institute for Citizenship and Globalization at Deakin University. He completed his PhD in International Relations at Deakin University on dynamics of a norm contestation in international relations, specifically examining how rising powers contest human rights protection norms, such as the responsibility to protect. And prior to that, Dr. Saba worked for over 10 years with the United Nations in Afghanistan. And the question for Dr. Saba will be around the responsibility to protect. And the question is, what is the responsibility to protect? And how does it relate to genocide in the situation of the Hazaras? And Dr. Saba, if you could respond to the question in relation to the early warning signs and patterns of genocidal acts that are currently ongoing. Over to you in 10 minutes. Thank you.
Thank you so much, Kobra. Let me also thank the organizing committee for this conference for putting this conference together, this timely conference together, and it's really an honor for me to be here and speak on this important topic. Well, it's not easy to find yourself as the last speaker, given the stellar line of speakers. I think previous speakers covered most of the topics, issues that really matters when it comes to prevention and protection of human rights, or prevention of mass atrocity crimes. To answer your question, I'll try not to repeat and avoid giving more context because it's been discussed in greater details. I'll briefly try to explain R2P, what is R2P and the core principles and how it relates to the genocidal violence against Hazaras in Afghanistan. And finally, I'll also propose some ideas as a way forward, what can be done moving forward, given the ongoing violence and genocidal violence against the Hazaras in Afghanistan. The responsibility to protect is in international norms, is a global commitment adopted by the United Nations member state in 2005. It holds that all states have a responsibility to protect populations from mass atrocity crimes, which includes the crime of genocide, war crimes, ethnic cleansing, and crimes against humanity. When a state fails in its primary responsibility to protect its own population, or worse, when a state itself is the perpetrator of those crimes, this responsibility shifts to the international community. But how does this doctrine of R2P, born out of a commitment to prevent atrocity crimes, relate to the unfolding situation that the Hazaras are facing in Afghanistan? To answer this question, as I mentioned, I'll briefly explain what is R2P, the core principles, and how it relates to the situation of the Hazaras in Afghanistan, given the ongoing genocidal violence that the Hazaras are facing in Afghanistan. But also, what are some of the key measures that the international community could take to prevent atrocities against the Hazaras? With regards to the responsibility to protect, at the core of R2P, it's about preventing mass atrocities. As I mentioned, these four international crimes. R2P rests on three key pillars. The first pillars is the state's responsibility, every individual state's responsibility to protect its population from genocide, war crimes, ethnic cleansing, and crimes against humanity. So it imposes both positive and negative obligations on a state. It does not create a new legal obligation. It is based on existing obligation the states has. For example, signing to the Genocide Convention and other legal charities or bodies at the international level. In terms of positive duties, negative duties, it requires the state not to commit any of those crimes or any massive human rights violation. But when it comes to the positive duties, it also obligates the states to prevent the occurrence of those crimes within its territorial control or in its territory. Then the second pillar of R2P relates to the role of international community. The international community has a responsibility to assist the states in fulfilling its primary responsibility. So this is more of a supporting role by the international community to the individual states, which may include provision of humanitarian assistance, military support, and other capacity building initiatives that build the capacity of a state, building the institutions, promoting rule of law, promoting human rights, building accountable institutions, so that the state can fulfill its primary obligation or responsibility when it comes to the protection, prevention of mass atrocity crimes. Then there is the third pillar of R2P, which requires the international community to intervene in cases when a state manifestly fails to protect its population. Either it's unwilling or a state itself is perpetrating such crimes. In this scenario, there are a range of measures that the international community can take, which includes from political measures, legal measures, economic measures in the form of sanctions, arm embargo, or some other legal actions, such as referring the case or the situation to the International Criminal Court or other international criminal justice mechanism. And the last hardcore measure under R2P that the international community take is military intervention, the use of force against the state that commits such crime. So this is the whole notion or the core principles of R2P, the three pillars. The state responsibility, the international responsibility to assist the state, fulfill its responsibility to protect. And lastly, when a state fails in its obligation, is the role of international community to take the responsibility to enforce those measures against the state. Again, as I mentioned, RTP is not just about the military intervention, although it's strongly associated with the military intervention, as we experienced in the case of Libya back in 2011, or attempt to intervene militarily in the Syrian crisis since 2011. But there are a range of measures that international community can take to fulfill its responsibility to protect. I think the previous speaker, Dr. Andrea, mentioned some of those measures that the international community could take to prevent mass atrocity crimes, including genocide. But how does RTP relate to genocide? As I mentioned earlier, one of the core purposes of RTP is to prevent genocide. RTP initially was born out of the international community's failure to prevent mass atrocity crimes, genocide, ethnic cleansing in the 1990s, the genocide in Rwanda, the genocide in the Balkans, Srebrenica. So it was that failure that led to the introduction of RTP. So in a sense, RTP tried to provide the ways as a policy framework, what exactly the international community, what exact role the international community could play in those situations where a state itself turns the gun against its own population. When returning to the situation of Hazaras in Afghanistan, I'm not going to repeat a lot because it has been covered by other speakers, what has been happening with the Hazaras in Afghanistan. All I want to say that the Hazaras has been facing or has been subjected to a vicious cycle of violence throughout centuries. There was a previous speaker talked about genocidal violence against Hazara during the reign of Amir Abdurrahman Khan. That's one phase, the beginning of genocidal violence against the Hazaras. And then moving further, more contemporary period, we have the civil war before the emergence of the Taliban back in the 1990s. And then we got the Taliban in the 1990s up to 2001. Another phase, a third phase of genocidal violence against the Hazaras. And then moving on post-2001 with the presence of international community, a semi-democratic republican system in Afghanistan. Again, the situation for Hazara did not change much in terms of its persecution, systematic discrimination. So we saw this evidence of systematic attacks, systematic discrimination against the Hazaras. The situation has further deteriorated since the collapse of the Afghan government and with the re-emergence of Taliban since August 2021. So this has been a vicious cycle of violence. And now, what can the international community do? Oh, there was a question as well, why it has not received much international attention to prevent the genocidal violence against the Hazaras. Part of this, I think previous speakers also, Mr. Mahmodi also mentioned this, that Abbas Faraso also talked about this, that we are living in a changing global environment. Afghanistan is not at the center of international attention. There are multiple other global crises that are grabbing the the attention of international media. That's one reason. The second reason is that there's no political will at the global level, especially with the major powers like the United States and the Western states, who used to be the main intervener, or those who used to be the major force behind enforcing global norms, international law. So that's one reason. What is the implication for prevention of mass atrocity, prevention of genocide in situations like Afghanistan? Is that it is this makes the case very hard for advocacy, for lobbying. So we need more work to do to get the attention of international community. As a way forward, what can be done? I'm thinking we need to draw attention to a two-pronged strategy: the responsibility to protect and also the responsibility to prosecute. The responsibility to protect is clear. There are clear measures clear measures that the international community can take, either through the United Nations or each state individually. For example, imposing sanctions on the Taliban regime is one measure that the international community or the United Nations can fulfill its responsibility to protect or pressure the Taliban. So this is one sort of measures, legal measures or economic measures that the international community can discharge its responsibility to protect. Another would be the which needs sustained advocacy is the establishment of fact-finding mission or a commission of inquiry. The international community has already done this in numerous cases, in the case of Syria, in the case of Iraq, in the case of Yazidis, in the case of Myanmar, for example. The Human Rights Council, the United Nations has established this investigative mechanism, which are important for the pursuit of justice and accountability in the long term. The significance of fact-finding mission or commission of inquiry is that it can, in the long term, it can lead to recognition of genocide or genocidal violence against the Hazaras. That's the first step. So to get there, I think we need a sustained advocacy, a sustained lobby to get these states to raise this issue or to support this idea of establishing such an investigative mechanism in the case of Afghanistan to focus or to investigate, to collect the evidence, document the evidence for future accountability procedures or mechanism. That's one way that we can work to get there in terms of the recognition of the genocide against Hazara, but also preserving those evidence and documents. There was a lot of discussions about in the previous panels and the previous speakers about what's going on with the Hazaras in terms of the hate speech, dehumanizations of the Hazaras, which strip the humanity out of this particular ethnic group. And once that is normalized, it justifies violence, it justifies killings. So this the establishment of such this investigative mechanism is significantly important to collect those evidence, to preserve those evidence, so that it can be used in future for accountability and justice purposes. So these are some of the ways forward that we can focus on to get the attention of the international community, or to help promote this the cause to get to the genocidal violence recognized against the Hazaras. In terms of the early warnings, I think Dr. Andrea covered them quite in greater detail. I'm not trying to repeat that. I just want to add that what is happening with the Hazaras in Afghanistan, it's past that stage of early warnings. Early warnings is before the onset of a genocidal violence, such as dehumanization, hate speech, which facilitate the onset of mass atrocity crimes or genocidal violence. Dr. Andrea mentioned the UN Atrocity Prevention Framework, the United States risk assessment for prevention of mass atrocities. Regina, the previous speaker, also talked about how they use the framework or the model that has been developed by the renowned genocide scholar Gregory Stanton to study the pattern of violence against the Hazaras. Kobra, yourself mentioned those 10 stages of genocide that Gregory Stanton has mentioned, which includes the classification, symbolization, discrimination, dehumanization, organization, polarization, preparation, persecution, extermination, and denial attained this stage. In fact, Stanton himself has argued that the Hazaras are already at stage 9, which is extermination. That's why we are talking of a full-blown genocide. For this reason, I think the early warning signs are not highly relevant. So instead, the focus should be on collecting this evidence, documenting this evidence. Majid Payman, the work that Bolak is doing, that's significant in terms of collection of those evidence, preserving those evidence, but also other Afghan civil society organizations such as Afghanistan Human Rights and Democracy Organization. They have done an amazing job in terms of, I'm sure Kobra, you know better because you've been involved in that project. So these are some of the measures that we as civil society, as actors can take in the absence of having a commission of inquiry or a fact-finding mission. Because these evidence is important for future accountability purposes and future justice and accountability procedures or mechanisms. Yeah, with that, I stop it here, and maybe we can talk more during the Q&A session. If there's any question. Thank you.
Thank you very much, Dr. Saba, for explaining the responsibility to protect state obligations and also mentioning, highlighting the 10 stages of genocide, as well as highlighting early warnings and the fact that we're past the early warning stages. Unfortunately, two of our panelists, Azadah and Dr. Gittleman, have left as they had other commitments. However, Dr. Gittleman has responded to the questions in regards to dialogue with states in relation to collection of intelligence. She said briefly on the question above, states have collected intelligence that they then share with international investigative mechanism. It has been shared with victim communities in limited cases, but see the US, the State Department conflict observatories on Sudan and Ukraine, for example. And to highlight also that recently the Afghan civil society at the OHCHR at the UN, they have been advocating for the UN, the OHCHR, the international community, to establish a UN independent investigative mechanism, an international independent investigative mechanism in relation to Afghanistan to be able to document, investigate, collect evidence, and preserve evidence in relation to international crimes or atrocity crimes, which also includes the crime of genocide. Since our other speakers have left, I would have to give some of the questions to Dr. Saba and Mr. Mahmodi. You will have to do the heavy lifting, my apologies. So there's a question about the current status of the Hazara community. Dr. Saba, I would like you to answer that, about what is the current status of the Hazara community in relation to the Australian government and society. Despite the existence of so many organizations, there's little progress or positive change. There's also a question about whether the Australian government has officially recognized the H.S.A.I genocide, and why are there so few discussions or topics on this at the Australian Parliament? If you could respond to that question. And also there's a question about the progress of the ICC. If you could provide an update on that, that would be great. Thank you.
Thank you. That's an important question. Well, we do have a sizable H.S.A.I diaspora here in Australia, and some work has been happening here, but we are still lagging behind some other countries like Canada and the UK. Before I come to Australia, I think it's important to highlight those positive steps in the case of UK, in the case of Canada. A good example of that is, in the case of the UK, is the parliamentary inquiry into the situation of H.S.A.I in Afghanistan, which they covered both Afghanistan and Pakistan. In 2022, I think, they published their findings in two separate reports, one focusing on Afghanistan and one focusing on the persecution of Hazaras in Pakistan. So those are, I think, very important steps. So a step in the right direction towards the eventual recognition of the genocide against Hazara. In the same way, there has been positive steps in Canada as well. There has been an ongoing parliamentary debate about the atrocities against Hazara. But compared to that, we have not had much progress here in Australia, but we do have a formal recognition at the local council level here in Melbourne, Australia, in the Melbourne city. So that is, I think, a positive step or a development towards the eventual goal of pushing or advocating for the recognition of genocide against the Hazaras. So there has been work going on in Australia, and a good example of that is the recognition of genocide against Hazara at the local council in Australia, which I think it's unprecedented. I haven't heard of any other such a formal recognition at a local government level anywhere in the world.
Thank you very much. And about the ICC process.
Oh, sorry, I forgot that one. Yeah, the ICC. Well, as I mentioned earlier, this is given the overall situation at the global level and so many crises that cries for intervention, cries for help, cries for international attention. Afghanistan, when it comes to the international criminal justice or international criminal prosecution, also lagging behind. First, it is the complexity of the Afghanistan case. When it comes to the work of ICC, ICC's work in Afghanistan is highly politicized or complex because any active investigation, it definitely involves the role that the international actors have played in Afghanistan, and particularly the United States, or the alleged war crimes and crimes, the war crimes that allegedly they have committed during the 20 years of their presence in Afghanistan. So that is a major issue, a complex issue that makes Afghanistan case for the ICC quite problematic or politically sensitive for the ICC. Although the International Criminal Court has formally started its investigation or looking into the situation of Afghanistan with the approval of the judges since 2017 or 18, I think, yeah. It's been quite slow. The positive news that came out was in late 2021 or early 2022, that the prosecutor of the International Criminal Court announced that they have decided to expedite its investigation into the situation in Afghanistan, particularly focusing on the crimes that has been committed by the non-state actors, especially the Taliban and the Islamic State Khorasan, the ISK. But it's still, even with that announcement that it will expedite and also limit its investigation into non-state actors, especially by crimes committed by the Taliban and the ISKP, still we haven't heard, at least in the public domain, there's no news about the progress of that ICC investigation into the situation in Afghanistan. So I think part of that issue is this complexity that the Afghanistan situation poses to the ICC. After all, ICC is also, I think, mindful or sensitive to its track record, failure, and success. So it's really difficult for ICC to get into a territory that really it gets it bogged down with major powers such as the United States. So that's the development with the ICC.
Thank you very much. Mr. Mahmodi, if you're there, I will pose two questions for you that has in the group chat. One is about the importance, how important is it for state political support to recognizing the genocide by the ICC international communities, Hazaras have not had any backing of any state. So the question is whether state political support is important when it comes to international investigations and accountability. And then there was another question about indifference to Hazara killings or deliberate killings. If you could highlight also in terms of why the indifference and silence to ongoing killings and violations and lack of acknowledgement. Thank you.
Well, thank you very much. Of course, the international system is designed in a way that the state actors are, their support are very important. But we should not forget that Afghanistan is a party still to the ICC, and the ICC has a jurisdictions over Afghanistan and a responsibility. And I think it has been slow in investigating human rights. These international crimes commitment in Afghanistan, but they are doing their job in a very silent kind of way. We are very unfortunate to not hear much from them, not get that much information from the ICC prosecutor and the investigative team. But they are doing, and it's also, as Dr. Saba mentioned, a very complex issue when it comes to Afghanistan, because the ICC cannot look on one side of the conflict or perpetrators. Afghanistan has been a party to the ICC since 2003, and the jurisdiction goes back to that time. And therefore, there were other actors involved in committing international crimes, including war crimes that many of the international partners that Afghanistan had at the time are, they have responsibility to answer to those kind of allegations that exist. And it is a very just thing to assume that they have the responsibility, and as if they want to support the ICC, all of the countries, all the state parties, whether they are party or not party, because Afghanistan is a party, and the crimes committed in Afghanistan brings the jurisdictions to Afghanistan and to any country who were involved in Afghanistan through their presence, their nationals and activities. So this is very important that we understand this complexity and also advocate at the international stage and also before the ICC, and facilitate the ICC work in Afghanistan. Now the ICC has asked us the UNAMA could assist them, and there are also issues with the testimonies from the witnesses, collecting data and information, and it requires a lot of logistics and a lot of resources. And I hope the ICC at the end of the day can overcome these logistical and resource issues, but also the complexity of their nature of work. And the one important aspect of the investigation that I hope that to be done in Afghanistan is the ICC, whether directly establishing, the crime of genocide, or looking at the atrocities against the Hazaras as crimes against humanity or war crime. These are very, very important to establish a precedent. The world has not been indifferent in a way that we think, but they have not been effective in doing something to prevent atrocities against the Hazaras. The world has always raised their voice in support of the Hazaras, and we saw that diplomats, investigators, special reporters, international human rights NGOs, they have all covered incidents in Afghanistan, and especially those against the Hazara community. But the problem that we see is that the ineffectiveness of the international human rights mechanism in doing something immediately and effectively. We have been now, unfortunately, and the human rights cause in general have been the victim of division in Security Council, and also the lack of um, any strong action from the Human Rights Council, the treaty bodies, because there is, it is very evident that the international community, all of those countries that are involved, have their own problems. There are allegations against Russia in Ukraine. There is a case going on against the Russians before the ICJ. There is allegations against China in regard to the Uyghurs. And also, Americans are involved in Afghanistan, were involved in Afghanistan, and many other European countries. So it makes the situation very complex, and it unfortunately, the UN and the international mechanism is the main actors are states. So if the states are unwilling or unable to do anything, the institutions by themselves cannot do much, because then the decision come from those organs that are led by those very, very strong members. The resources come from those countries, and also the security and safety measures in the form of peacekeeping or other measures come from those states. So this is very important to understand this complexity of the international, regime, especially in absence of a global governance system, because still there are states that are very, very strong in preserving their sovereignty. They don't allow any countries to interfere in their sovereignties, despite the responsibility to protect, and others, they want also to apply it on situations that this type of atrocities are going on, and we see the reluctance of the countries to do anything meaningfully in Syria, in Myanmar, in Afghanistan, other than litigation before the ICJ, which is time-consuming and at the end of the day very much dependent upon the decisions of the groups that controlling the states in those situations. But there is hope. The hope is that Afghanistan civil society groups and networks come together. We also should educate our constituents and Afghan people and population, academias, about the need for a united front and united advocacy before the international institutions. Issues like genocides are both from the international security law perspective, from international human rights law perspective, and from the international criminal law perspectives are very important. This is why that we have to work with the institutions like ICC, UN reporters, and others to establish first the fact that genocide has occurred in Afghanistan and perpetrated by groups, both state and non-state actors. But also it's a danger in the future, maybe imminent, maybe in the future it's coming. And we see that whenever there is an opportunity for actors to react against the Hazaras, they use that opportunity and attack, and they are just seeking vulnerabilities and places. So I think there is a mix of response to these two questions. One is that, yes, we should do a lot of advocacy and hope for the states to support us, not because of Afghanistan Hazaras, but because of their obligation and under international security law, international human rights law, international criminal law. but also for the safety of the future peace and security in the region and globally, because Afghanistan shown that if it's not uh, 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 considered important, the inflict of harm to the global security would be possible from Afghanistan. And now I see that there are threats against the stability in the region from Afghanistan, emanating from Afghanistan. So this is very important to understand and invest in litigation. I think one thing that we as a Hazara community or advocacy groups for the prevention of genocide and atrocities in Afghanistan should do and must do is to bring together resources to start litigation. We have done good work in reporting, in writing, in researching, but we have not done enough in litigating cases against perpetrators. And that venue is very, very much open to us, and I think we have to try that, and it needs to bring together our lawyers, our litigators, and renowned investigators and academic scholars together to put together a strategy how we can assist the ICC, how to pursue states to champion for Afghanistan, Hazaras to bring Afghanistan to ICG, and also to individually in the countries that apply universal jurisdictions. This is important that to be identify cases, identify perpetrators, and bring them to courts there and use their justice mechanism and justice system and prosecutorial capacity to bring the perpetrators to an account. And it is very unfortunate that the Taliban leaders are, despite their notorious reputation for committing crimes, they are moving around, traveling to different capitals, and this framework of justice has not been applied or exhausted to bring them to justice. And I think it could be started by applying the jurisdiction in Europe, as it was done by Syrians, by other countries. We should do that, and also in other countries like Australia, the US, and other places. And I think once we start there, and we could see result. And unfortunately, the bad news is that there isn't any immediate remedy for anyone that is in danger or already suffered and become victim of these atrocities in Afghanistan.
Thank you very much, Mr. Mahmodi, and thank you to all the listeners. Thank you for your patience. I know that we're well over time. Apologies that we cannot respond to the rest of your questions, given the time limitations. However, the work does not end here. Our collective efforts and discussions, we have a long way towards the acknowledgement, recognition, investigation, and accountability for crimes perpetrated against the Hazaras. And what we have learned from today's conference is the importance of taking a multidisciplinary approach, as Dr. Azadah noted, and a comprehensive approach to both theorizing or understanding the concept of genocide, but also on the type of accountability mechanisms that we can pursue. And as Mr. Mahmoudi highlighted, the importance of litigation and judicial action, but then there's also non-judicial action, in particular for historical crimes where those perpetrators are no longer alive, and that's where truth-telling, acknowledgement, and bottom-up approaches, arts-based approaches are really important. However, discussion, research, collaboration are key, and given that, I would also like to thank the organizers for putting this conference together, and I will pass on to them to conclude. Over to you. Thank you.
A special thanks to you, Ms. Kobra Moradi, and to all panel members for the enriching conversation you just had. Your insights are truly appreciated. And once again, thanks to both panel moderators and panelists for such wonderful discussion they just had. As we wrap up today's conference, I would like to invite Mr. Reza Hassan, a PhD scholar at South Asian University in India and a member of the organizing team for today's conference, to share some concluding remarks with us. Mr. Hassan?
Thank you so much. I think we ran a little short of time, so I'll just I'll not talk or conclude. We will keep the detailed conclusion or the takeaways of today's conference for a detailed report, which we will try to prepare in a matter of week or two. I just want to thank all the participants for actively engaging and participating in our first conference. This was our first experience, and hopefully we will organize more of such conferences in future. And we would like to thank Professor William Molly for delivering the keynote address. His invaluable insights were really enriching, and we hope to have him in our future events. Further, we would like to thank Mr. Rustam Sirat for presenting and also for moderating our first panel. We would like to thank Mr. Gina and Timothy for from Bar Association for presenting their report and paper. Thanks to Block Network and Ms. Mechit Paimon. And thank you so much to our first and second panelists. Thanks to Dr. Nematullah Ibrahimi, Dr. Farhunda Akbari, Dr. Abbas Farasu, and Mr. Bismillah Ali Azadah. Thank you, Ms. Kobra Moradi, for moderating such a wonderful panel. And we would like to thank Mr. Musa Mahmodi, Dr. Andrea, Dr. Saba, and Ms. Azadah, who really had a very fruitful discussion on international law perspectives dimensions. In today's conference, we had discussion on various aspects of H.S.A.I genocide, and as one of our panelists, Mr. Bismillah Ali Azadah, mentioned, this is one of the most under-researched or under-studied issues. We hope that our researchers, our PhD students and activists would do more documentation, more research in this area. This is, of course, as Mr. Mahmodi mentioned, genocide, and Mrs. Dr. Saba also mentioned that has all the dimensions of genocide. And that's the most important part, that we recognize and we know how it has been working and how it should work in the future. So hopefully our participants, our panelists, and our researchers would work in to further do more studies in this and organize more events. That's what I wanted to mention. And thanks to Mr. Stephen Van Orden, human rights officers of the United Nations, for actively participating in this conference. I also would like to thank my colleagues in the Association of Hazara Voice for Justice and the Association of Hazara Students in India. Our technical team, Mr. Bashir Ibrahimi at Murtaza H.S.A.I, Abdullah Etumadi, and our other members of both association, Hadi Haidari, Muhammad Ali Irfan, Reza Rezai, Ahmad Safa Khesra, Gulnigar Ahmadi, Ali Sina Faizi, Razia Moradi, and Sumaya Adina. Thank you all. Have a great day. Have a great night. Have a good time. And see you. Good night.